Hello and Assalamualaikum warahmatullahi wabarakatuh. To all that is watching the video, we are currently going to present to you about the assignment 2 of commercial law. So first of all, let me introduce myself. My name is Muhammad Nabil bin Muhammad Isa. Currently studying in a course of Bachelor in Accountancy and currently taking commercial law subject.
Assalamualaikum warahmatullahi wabarakatuh, and hi, my name is Muhammad Raib bin Razam. I am Bachelor in Accounting student. Currently, I am studying commercial law subject.
My name is Sharunizam bin Rashid Muhammad. Currently, I am taking course BIA, Bachelor in Accounting, and taking commercial law subject.
Hello, my name is Muhammad Irfan and I'm taking Bachelor in Accounting. Right now I'm doing assignment 4, subject commercial law.
Hi, my name is Zavro. I'm taking Bachelor in Accounting and I'm studying commercial law subject.
For the introduction, we in assignment 2 in commercial law, we need to make a slide presentation of a case study with the main topic of hire purchase. Our group consists of 5 people and each student participated in the case study. The submission medium is through e-class on 4th May and the leader of this assignment is me, Muhammad Nabil bin Muhammad Isa. Based on the case study, we need to give our answers in the slide and present in the form of a video. So, we move to question 1.
For question 1, for our assignment was, Sulaiman want to operate a food truck business. He planned to purchase truck from Seesaw Motor, which will be financed by Venture Bank. Sulaiman approached his old friend, which is Nizam, to become his guarantor for the hire purchase agreement with the Venture Bank. So Nizam, however, quite unsure whether there would be any kind of liability if he become the guarantor to Sulaiman. So for this assignment, we shall advise Nizam.
Okay, now we move to issue question 1. The issue here is that whether Nizam will become liable when he became a guarantor during the hire purchase if there is any unprecedented event that will happen. This issue states that if the Nizam wanted to know if he will be claimed for any sue or for anything if he became a guarantor. So he want to know what is the risk that he is willing to take if he becomes a guarantor. So we move to the general principle of law. The general principle that is related to this question is hire purchase, which is letting of goods with an option to purchase and an agreement for the purchased goods by installments. Means that there is an option. There is 2 options actually. Option to purchase or to purchase goods by installment. Letting goods or purchase goods by installment. That's the 2 options. It is either an agreement describes for installment as rent or hire or otherwise. Okay, the second principle that is related is owner. Owner is a person who lets goods to a hirer under her hire purchase agreement. Owner is someone who just gives his belonging, his property, asset to people in order for him to get a benefit. So hirer, as I mentioned, hirer is the person who takes or has taken goods from an owner under a hire purchase agreement. So both have an agreement. And a guarantor is a person who acted on behalf of the owner. So it means that the owner needs to hire the guarantor. So in section 31 1B of the Hire Purchase Act 1967, if any owner, dealer, agent fails to deliver the goods, the owner, dealer or agent shall refund the full amount of the deposit to the owner, to the hirer, sorry. So if the payment of hirer to the owner doesn't directly go to the owner, the agent or someone that is involved shall be liable to refund all the amount that has been paid. So next we will move to the case law of this question. The case law related is that we found is Hong Leong Finance Berhad versus Max Double Construction Sdn Berhad. The facts of this case is the first defendant had entered into certain hire purchase agreement with the plaintiff. Okay. The second to fourth defendant were the joint and several guarantors under this hire purchase agreement. Means that between the owner and the hirer have a few guarantors and agent. So they have an agreement of hire purchase. So in 1988, when the first defendant committed a default by its failure to make payment of the installment due, the plaintiff issued a letter of demand. Thereafter, the plaintiff commenced legal action in the High Court to claim against the first defendant for sum owed under the hire purchase agreement. So, what the plaintiff did was right. He already made a letter of demand noticing the defendant of the owner repossessing the property. So the judgment of this case is the first defendant was liable to pay the plaintiff the sum demanded under the 7 hire purchase agreement as per notice of demand. So because of this demand, all the 7 agreements, they have made 7 agreements. All that 7 agreements will be liable to the first defendant, and the parties were bound by the agreements they signed, and the second and fourth defendants were therefore liable to pay the plaintiff. Means that all that is related to the first defendant, including the second, third, fourth defendant, is needed to pay the leftover of what the first defendant could not pay to the owner. So after case law, we move to the application.
Okay, referring to Sulaiman and Nizam case, if Nizam willing to be the guarantor for Sulaiman, he are pretty much liable for Sulaiman debt until the amount is completely paid off. This case can refer to the section 31(1)(b) of the Hire Purchase Agreement Act 1967, whereby if any owner, dealer, agent fail to deliver the goods, the owner, dealer or agent shall refund the full amount of the deposit to the hirer. So in this case, Nizam also tied by the Hire Purchase Agreement, same as well to Sulaiman. And also Nizam accountable to pay for Sulaiman debt if he failed to do so. In this case, it's also similar to the case of Hong Leong Finance Berhad versus Max Double Construction Sdn Berhad, which is Nabil already explained just now. Okay, now we move to the conclusion of this case study. I should advise Nizam that if he willing to become the guarantor for Sulaiman, he must be prepared for responsibility on behalf of Sulaiman if there are unprecedented event. That means if Sulaiman are not willing or couldn't pay the debt to the owner, so Nizam as the guarantor should do so. In other words, Nizam also reserved the right to request and receive the hire purchase agreement as same as Sulaiman. In addition, Nizam also has the right to receive all the notice on payment issued by the financial institution to Sulaiman. So next we move to the second case study.
Now we move to question 2. Question is, assuming Sulaiman proceeds with the purchase of the truck as mentioned in question 1 above. However, it is quite unfortunate during the monsoon season recently. Sulaiman could not make good profit in his business. Consequently, he has defaulted in making 2 monthly installment payments. Venture Bank is now taken a step to repossess the truck. Advise Sulaiman on his right in this situation. Next, we move to issue. The issue is whether Sulaiman has the right to oppose the repossession of truck by Venture Bank and what is his right. Next, we move to general principle of law, and I pass to Muhammad Irfan.
Okay, so for the general principle of question 2, as Nabil said earlier, it's quite similar. The first point is hire purchase, letting go of goods with an option to purchase. An agreement for the purchase of goods by installment is either an agreement described as installment or hire, or otherwise anything as mentioned. And also, in every hire purchase agreement, there shall be an implied condition on the part of the owner that he shall have a right to sell the goods at the time when the property is to pass. So, under section 16.1, which HPA, an owner may repossess the goods provided if the hirer has defaulted to unsuccessful payment. In this case, in section 18.1a, within 21 days after the receipt of 5th schedule notice, hirer may request the owner to redeliver the goods after the hirer paid the amount due, remedies for any breach of agreement, and pay the cost incurred in taking possession of the goods. And finally, the hirer also can require the owner to sell the goods to any person introduced by the hirer who is prepared to buy the good only by cash. So the hirer can introduce any other third party to the owner and on behalf of him to buy the truck or any goods, but only by cash. That's for general principle.
So, the case law for question 2 is Pang Brothers Motors, Sunia Berhad versus Lee Ai Sang. So, the fact is, a car was taken by the respondent on hire purchase with the appellant. The respondent failed to pay the installment due and the appellant issued a notice under section 16A. The issue was whether the notice was in fact served. The head of this case is section 16, clearly that period before which the seizure can take place shall be not less than 21 days after the service of the notice. However, the date specific in the notice was 2 days short of the statutory minimum, and the notice was therefore bad in law even if served, and its effect was therefore null and void. After repossession, within 21 days after the owner has taken possession of goods that were comprised in a hire purchase agreement, he shall serve on the hirer and every guarantor of the hirer a notice in writing in the form set out in the 5th schedule, section 16.3. Where the owner take possession of goods, he shall deliver to the hirer personally a document acknowledging receipt of the goods, section 16.4.
Okay. For application, as Farouk mentioned earlier in the case law, referring to the case of the Sulaiman and Venture right now, Sulaiman has defaulted in making 2 payments for 2 months consequently, which made the Venture Bank to repossess it up. As we mentioned earlier, referring to Section 18.1, within 21 days after the receipt of fifth delivery notice, hirer may request the owner to redeliver the goods. In this case, Sulaiman cannot breach the agreement made by Venture Bank, but after the repossession of the truck, Sulaiman have to pay the amount due and other amount if Sulaiman wants to take the truck from Venture Bank. In this case, is similar to the case of Pang Brothers Motors, which was the car taken away by the owner because of breaching the agreement failure to pay the installment to Pang Brothers. What can Sulaiman do? His rights are he can ask for the documents, or he can terminate the contract which he has between Venture Bank, and also he can pay the amount due or any other amount comes out with it to to get back the truck that was reprocessed by the Venture Bank. I think that's all for application. We may move on to the conclusion.
For the conclusion in this question is, in the light of this learning, Venture Bank have the right to repossess the truck because Sulaiman has breached the agreement between both parties. Sulaiman have the right to request the owner to redeliver the truck that was taken by Venture Bank after paying the amount needed to be paid. The amount due, remedies for any breach of agreement, pay the costs incurred in taking possession of the goods. Other than that, Sulaiman can also introduce a third party to the Venture Bank to buy the truck by cash at a price not less than the estimate value of goods set out in the notice by the owner. That's only from me.